Welcome to Jackson Lewis's podcast, We Get Work. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question on every organization's mind: how will my business be impacted? For U.S. companies that allow employees to temporarily work abroad, it is critical, from a compliance perspective, that employment policies take into account these flexible work arrangements. On this episode of We Get Work, we explore scenarios involving short-term international assignments, including tax treaties, employee benefits obligations, digital nomad visas, and the importance of remote work policies and agreements. Today's hosts are Chris Anderson and Melissa Ostrower, principals, respectively, in the Greenville and New York City offices of Jackson Lewis. Chris and Melissa, the question on everyone's mind today is, what steps do U.S. employers that allow temporary remote work abroad need to take to remain compliant with U.S. employee tax and benefits policies? And how will that impact my business?
Thanks, Alicia. As Alicia said, I'm Chris Anderson. I'm a principal here at Jackson Lewis in the International Employment Practice Group. And remote work is a huge part of what I do on a daily basis. It's not the only thing, but it's something that's been coming up increasingly, especially after COVID hit. And then the outworkings of that over the last 4 years is I deal with this issue from many different angles on a weekly basis, and can anticipate continuing to do that based on those past clients I've already been working with. And I'm here today with Melissa Ostrower, one of the co-leads of our employee benefits practice group. Welcome, Melissa.
Thank you very much, Chris.
Glad you're with me for sure, because I needed to bring in a heavy hitter on this topic. We're talking about part two. This is part two of our series on global remote work, and this is on tax and benefits. And so an area where I don't pretend to know it all by any means, and am just good at issue spotting and calling out things for clients. And so thank you for being here to talk about it. And as we get going, Melissa, I really wanted just to start off really broadly with, because I think it'd be great for all the listeners out there who happen to hear this, in your practice. Let's just start with how this comes up, global remote work. And just to give it a little bit of parameters, is we're talking about global remote work of U.S. employees, whether they be non-immigrant employees in the U.S. on a J-1 or an L visa or something, H-1B, or a U.S. citizen who ask their employer, or maybe they don't ask, maybe they just go, but the employer finds out they're there for personal reasons in some other country, or they ask to go for personal reasons, and they want to go work for a short-term period of time. And we'll kind of define some parameters around that as we talk, but just a short-term with an intent to return. So the idea is to stay on U.S. payroll, continue paying everything in the U.S., and they want to go overseas for vacation or otherwise. How have you seen this come up the most in your practice from a tax and benefits perspective?
Thank you. This definitely has come up frequently. This is really the logical extension of kind of the question that we get in the domestic context when employees go and work in different states. Well, also employees go and they leave the United States and they go and work in different countries. And that raises a whole host of issues for employers and risks. And so the first thing is that employers have to understand kind of where the employee is going, for how long, and then it needs to kind of be proactive and take action. For example, some countries have income tax treaties with us, and so we'll want to consult those treaties to see how the employee is going to be taxed abroad. We will also review how the employee is going to be taxed here. Often, if an employee continues to work for the U.S. employer and is abroad for less than 6 months, less than 183 days, there may be a treaty provision which will allow the employee really to just remain subject to income taxes in the U.S., but not always.
So on that one, let me ask you one thing on that, because that's something that comes up all the time, and it's a great spot where I don't know what I don't know, and I'm issue spotting, and I'm dealing with clients, and I've done this hundreds of times now. But is it fairly safe to say, and we're not giving definitive advice here by any means, but is it fairly safe to say that when a country has a tax treaty with the U.S., a bilateral tax agreement, and it has that 183-day rule or any alternative rule, that as long as the remote work follows that rule and the person stays on U.S. payroll, that there's not going to be a personal income tax issue in that country. Is that fairly safe to say?
No, I absolutely don't. I don't think so, because especially with the fact pattern that you mentioned, where some of these folks might actually be here on visas. So maybe they're going back to their country where they are a resident or a tax resident. And so it may be that the treaties don't apply in the way we kind of expect that they would apply if it was a straight up U.S. citizen going there. Really isn't going to qualify as a
that's
resident.
A great point. Yeah. So if it's a national of that country going home, then they have citizenship, they may have a house there still. All those issues.
And so the treaty may apply differently. And so why does the employer care, right? I mean, at the end of the day, we're representing employers here at Jackson Lewis. And so the employer cares from a tax side because the employer could have some withholding obligation. The employer could have some reporting obligation. With respect to the employee. And then I think we'll get to this a little later, could this employee be kind of creating what we call a permanent establishment there, a business there that could subject the company to like company level taxes. And so, that's why we care. Now, ultimately the employee, has some exposure as well, and could be subject to taxes there, and we don't want our employees to be unhappy. But of course, in this situation, it sounds like the employees are going there because they want to. And so that is an issue for the employee. There are different rules.
One question on that real quick. Would you say do you think it's more risky, and it's going to be case dependent, I know, but just tell me from your practice, is it more risky for the employee themselves than the employer in the classic case of someone going on vacation, going back home for an extended holiday? Is it typically going to be more risky as long as that U.S. company doesn't have a presence in that country or other activities there? And that kind of, we can boil it down to that simple case, which is what I deal with for the vast majority of cases. It's like that. Would you say the more risk is on the employee or the employer?
I think it depends on the duration, the employee, the level of the employee, what they're doing. A vacation over the holidays for a few weeks, I think it's lower risk. Again, with your fact pattern where some of these employees may actually be residents of the country where they're visiting, they may already be paying taxes there, right? So, perhaps it's not such a big deal for them. But, I think it depends on the country and the duration and the person. But I think the real risk comes when it's longer, right? When it's someone who wants to go there for more than 90 days, they're going to be really working for them.
And many of my clients, what they'll end up doing is making 6 months their absolute, and I always encourage one, to get a tax opinion, and then two, to keep it as short as possible, right? I mean, that's practical advice. And not only from a tax standpoint or employment or immigration, all the things that we're talking about in this series, but just from a practical precedent setting perspective as well. Just, you don't want to, once you create this precedent, you're going to have more employees wanting to do it, especially for these personal reasons. But let me ask a little deeper on the initial question really quick about if the initial question you said no to, which was great. And it was absolutely right to say that because it's nuanced, right? There's a lot of facts here. But so if it's a non-national of that country, so someone who's a U.S. citizen going and there's a tax treaty and they're going and they don't have a home or other ties to that country, and the treaty gives, let's just use the hypothetical 183-day rule, which typically they do have, and they stay underneath that 6 months, can U.S. employers feel fairly confident that and can that person feel fairly confident there's not going to be a personal income tax issue in the country?
So, I mean, generally, yes, but there can be some nuances, like, are they doing something that could create a residency for them, which we don't know. But what we always do here, at Jackson Lewis, we're part of this the L&E Global Alliance. And so we, as the U.S. lawyers, review it from the U.S. side, but we do bring in the foreign counsel because we don't know those rules as well and those nuances. And we also make sure that we get their input because there could be some foreign aspect that we're not reviewing or considering that we'll want to get their input on. But yes, generally, I would say a U.S. citizen going over to a country to work for the U.S. employer with one of these treaties where the employee is not doing anything to cause that employee to become a resident in the foreign country, then generally that's going to apply, and which means that we'll just continue on withholding the U.S. income taxes like we were.
Yeah. And that's a great point, Melissa, because while, and again, not trying to pin you down on that at all, because, but I wanted to just to be clear for listeners as far as in that case where it is a U.S. citizen. But a lot of these cases that I deal with, it is someone, oftentimes someone who's here on a non-immigrant visa who wants to go home, and they may or may not have their residence still, they're seeing family. So just an important point for anyone listening to make sure you're looking at it from that deeper angle. That's a great point you raised. And thank you for raising about L&E Global. As part of the international group, I deal with our colleagues at L&E Global on a daily basis, and they are amazing. So absolutely, that's how we get our work done, is by liaisoning with them to go deeper as we need to in these areas. But we would always tell a client to get a tax opinion, whether through our L&E Global colleagues or through another tax advisor as needed in the specific country. So let's talk a little bit about when there's not a tax treaty. Just give your general, overview advice on how to handle that when, and the additional risk it raises when there's not a tax treaty in place between the U.S. and the remote work country.
So again, we'd have to, it's country by country, but oftentimes kind of you become subject to income taxes based on where the services are being performed. So the individual, working abroad could be subject to income taxes in that foreign country, and we could have a withholding obligation in that country. Now, in the U.S. and our domestic tax code, a citizen who works abroad that is subject to mandatory income tax withholding of a foreign country, then we don't have to withhold the U.S. income tax, at least at the federal level. So, it's important to know and understand, and then to withhold in the foreign country, like we have to. Mm-hmm. But then we won't have to do it here. Different rules for residents.
And would the withholding in the foreign country, would that typically ride on whether what you're doing and what that person's doing, the activities create a permanent establishment, or could there be a withholding obligation just based on having a person there?
Yeah, it doesn't have to have, you don't have to have a permanent. It's just the fact that they're working there, they just like here, just like if someone comes over to the US and starts working, in the absence of a treaty and subject to certain exceptions, they're going to be subject to income tax here. So again, you have to be aware of it, and you have to actually be doing the withholding. And so I think with the employees who go over for a brief time, the employers probably aren't aware. But if you come to us with this question, it's probably because it's more than just over the holidays. They're probably asking for a longer term assignment. And I think in that case, we would, for income tax purposes, we would bring in, some foreign counsel to help us, advise us. And, perhaps we could, use a payroll company over there to help this, because we're not in a position really to do the.
Yeah, I was about to say that. We can't run payroll, right? Unless you have a permanent establishment or brick and mortar presence. You can't run payroll. So getting an EOR involved, which would be an employer of record, for anyone wondering what that means. But EOR, or running, if it's certain European countries, you can run a payroll and register as a non-resident employer, and some other countries around the world too. But that's definitely a case-by-case basis. So
can I add in? So I've been talking about income tax so far, but there's also Social Security tax issues to consider. And, and there are some treaties that are called totalization agreements, and they sometimes can permit, they're there to avoid double taxation so that employees are not paying Social Security type taxes in more than one country. So there aren't as many of those as income tax treaties. But typically, unless you are working for a U.S. company who sends you over on assignment to the foreign country for less than 5 years, you're not going to be eligible to qualify for an exemption. So the employee working abroad could also potentially be subject to the Social Security or equivalent taxes in the foreign country, and then also still be subject to our FICA taxes here.
Right. Yeah. Good. That's a great point to make, and because it is two sides of a coin. But often I found that many of the countries that we have tax treaties with, we may not have a totalization agreement. It's far less in general than we have many more tax treaties than totalization agreements, from what I've seen. And this has come up in my practice where clients of mine have applied for that totalization agreement based on the remote work, when they wouldn't do that for a 2 week or 1 month, maybe even 2 month period typically, although there's no hard and fast rule on that. But even for a 4, 5, 6 or month or more remote work period, when they applied for it, many of my clients have gotten it, the certificate of coverage, showing they're still covered in the U.S. and therefore exempt in the other country. But I've had a few clients who have had a struggle with getting it. Have you had any particular clients that have?
That's a great point. So I agree with you, because in this fact pattern that you've mentioned, it is not the company that is sending the employee to work for the company on assignment. It's really more of a personal decision for the employee to work remotely. And for the first time, I have been seeing clients come to us saying that their request for a certificate of coverage has been denied on the basis of this remote work. It does not meet the terms of the totalization agreement to be kind of eligible to not be subject to the Social Security taxes of one of the countries, and that you could, and the employee could end up being subject to both.
So so at that point, are you kind of just in a little bit of a pickle because you can't know definitively, which gets back to having a policy and enforcing it. And it may be one of the listeners' gating mechanisms of, if we can't get that, we're not going to let you go, because we're in an unknown and ambiguous state of knowing whether we have exposure or not at that point.
Or actually, I think rather that you have to pay both in both places. Right. So if you're not exempt from Social Security in one of the countries, then, it could be expensive for the employer, especially in some of the European countries, right? The employer has to pay quite a bit. In the US too, there's the employer share of the FICA taxes.
And that's the same thing as with tax though, as well, because unless you have a presence and an entity, you can't pay in many countries. And I've actually looked at this probably in 50 plus countries, both the tax and the social security part, social insurance part. And often, not always, but often my local colleagues around the world in L&E Global and in other countries as well will say, well, unless you have a permanent establishment, there's no affirmative responsibility. Therefore, they take the position that there's no material risk for the U.S. employer, there's mainly the risk for the person. But then when I press on it and say, well, what if the person doesn't pay their taxes? And they almost always say, won't say always, but almost always will say, well, we can't say this without risk. So again, there's this exposure is there that unless you run that payroll and do the social insurance there, that's the only way to be fully compliant, is to take that step. Once unless you have the certificate. One of the comments you made a little bit ago with someone where there's not a tax treaty with their country, the country of remote work between the U.S. and that country, if they're there for less than 6 months, often countries, not always, often have a 183-day rule for their own tax residency. But even if they're non-resident, I've talked to some of the big four accounting firms and other local accounting firms around the world, and often countries take the position that anything you make on that soil from day one, if there's no tax treaty, would be subject to income tax in that country. It's not your worldwide income. That happens after you become a tax resident, but it will be whatever you make on that soil. Have you heard that or dealt with that in your practice with other colleagues outside the U.S.?
Yeah, I think that is the general rule,
okay.
Right? The general rule of most countries other than the U.S. and China, I believe, is that you're subject to tax in the jurisdiction where you earn it, you perform the services. And so just like you said, if there's no treaty, the individual who's working in the foreign country would be subject to tax on the money earned there. Now, the U.S. is a little unique in that we tax our residents on their worldwide income, but not all countries do that. So, in the U.S., even when you're a non-resident, you are subject to tax. A non-resident would be subject on the income earned while performing services in the U.S. So, but again, since we represent employers here at Jackson Lewis, we're looking at it. Okay, well, what does that mean from the employer's perspective? And that means you have to withhold, you have to report. Are you creating a permanent establishment? What else? What's the impact at the employer level? And so typically your withholding obligations apply when the income is subject to tax. So if the employee is subject to tax on that income from day one, then the employer may have had a withholding obligation from day one and a Social Security.
Right. Well, we could talk about this for an hour for sure. It's so deep with permanent establishment too. Maybe we'll have to do a follow-up podcast just on that alone, because I've dealt with it so much. And I know you have, just the ins and outs of what can trigger that. And every country, tax treaties have different things. I've even noticed some of the tax treaties that we have with other countries have a services provision for PE, that permanent establishment, that says if you're there X number of days doing any kind of services, the tax authority could find that's a permanent establishment. And I've had to look into that with local colleagues many times before. But let's pivot really quickly as we kind of get towards the end and talk just about, I'd love to hear your benefits experience of how remote work, global remote work for short-term periods can affect benefits, medical benefits, and 401k especially.
Sure. So there's like the technical kind of compliance aspect, and then there's the practical aspect, right, of whether their employee will get the desired benefit. So kind of the main benefit we all think of, I think of when we think of employee benefits is the health insurance, right? So if an employee is enrolled in your medical plan here, they're abroad, typically the US plan is not going to have a network of providers abroad. So unless that employee is fine kind of coming back here for medical care, then it may not serve the employee's purpose. Now, again, if this is a situation where the employee is going over for the employee's benefit, sometimes employers may just not want to address it, but there are, international plans, which typically employers offer when they're sending employees to go work abroad, which is also a common situation. And so, you may want to look into getting one of these kind of international plans that's going to provide more useful coverage on that. Then you have to look at all the other plans. Like, for example, you may have life and death, disability, and some of those plans, typically they're insured and they do have exclusions, for working outside the US. So right. You want to look at those and you want to understand the impact of someone working abroad has on the benefit.
Yeah, and that's I'm glad you raised that about other plans as well and the exclusions that are there, because we're living, I think this whole series, if I could really sum up kind of what I was thinking and trying to get a 3-part series, was looking at these things that have arisen with remote work that 5 years ago, 6 years ago really wasn't a thing. It just wasn't there. So the law has to catch up with the reality. We see it with the certificates of coverage we talked about a minute ago. You see it with these plans where many plans that I've seen often will handle what would be a classic business trip historically, right? In 2 weeks, 3 weeks, whatever that was in the plan. But now we're talking about people wanting to, I had someone the other day, a client came to me and said, we have someone who's demanding to go home 3 times a year for at least 2 months each time. So that's, half the year they want to be at home and just stagger it all, going forward. And so we had a very robust conversation about that. But the law hasn't caught up with that yet. And kind of one last thing from my side that I'll talk about probably in every episode is digital nomad visas or remote work visas that have been popping up. And I want to ask your opinion on one thing to close, Melissa, on this. But these visas allow for someone to remote work, and it's the law catching up with the reality where many countries, and by now it's 70 plus countries at this point, have some sort of a digital nomad visa. But in your practice, Melissa, have you seen this come up? And do you think that the digital nomad visa, if someone gets it, typically would cover them from a personal income tax standpoint in that country, if you've dealt with that before?
Right. So again, in that case, in the foreign country, we would rely on the foreign counsel, but we would still look at it in our practice here at Jackson Lewis from the U.S. side. So what does that mean? Like I mentioned before, a U.S. citizen going to work abroad for the U.S. company would generally still have wages subject to income tax withholding. However, if the employee is subject to mandatory withholding in the foreign country, then you wouldn't have to withhold. So in that case, we would need to know maybe that employee, if they're not subject to tax in the foreign jurisdiction and there isn't the withholding exclusion or also the foreign tax credit I didn't mention, but that we would still have to withhold. So we would look at that in the context of what the employer has to do, and it could impact kind of the treatment because of that visa.
Yeah, and I've looked into this a good bit because it's something I'm doing all the time with our foreign colleagues. And what I've started seeing coming up, and it really goes with your point, is obviously it's case by case basis. But what we're seeing is some of these digital nomad visas very squarely address. They all address immigration. That's what they're there for, is to allow you to come and reside legally and perform work for a foreign entity while you're there. But what they don't squarely address often is tax, social insurance, and employment. They don't often hit it right on the head. There's some kind of assumed coverage you get, but it's not always clear. So I would just encourage our listeners to look at that, reach out to us, and we'll bring in the right foreign counsel to be able to opine on that more. Some of them do squarely address it. There's a few that I'm thinking about in some island nations that you very clearly say you will not pay tax. It's not towards residency, but it is something that has to be addressed case by case for sure, both U.S. and abroad. And just to close from my side, there's some risk mitigation strategies. I'd love for you to chime in on any of these, Melissa, as well. But I always recommend for my clients to do a remote work policy. I'll talk about that in every episode, and do a remote work agreement for setting expectations, making sure you have a defined time period, whatever that ends up being, that's either you're not going to allow it, or if you do allow it, making sure that you've looked into the tax issues of it. We'll focus in on that. Melissa, have you dealt with remote work agreements or remote work policies with your clients?
Absolutely. And I think this actually, going back to kind of how I started, this also, we do this for clients with working in different states as well, right? So I think it could really be in the same policy. If you're working in a location other than kind of where your home base is, you have to, one, make sure that the policy permits it. And some employers say, you know what, we'll help our employees and we'll pick these whatever 10 jurisdictions or whatever we'll allow it so we can make sure we're compliant. But otherwise, you can't work remotely. Other times, it's subject to approval. There's different approaches, but I completely agree. A policy, sets the parameters and, the expectations and makes it more likely that you're going to make sure you're in compliance because you've told your employees what you're expecting and they hopefully will give you the information you need to make sure you're compliant.
Great word. And just to close this episode from my side, we always recommend, we said it throughout, but just getting reaching out to us, Melissa, her team on the US side, they'll bring in our international team. And we just love assisting clients in that way, but getting a tax analysis done, issue spotting, and then going as deep as you need to feel good. And all the stakeholders are on the same page so that your eyes wide open going into this, and we're able to foot forward, say, no, we're not allowing it for XYZ reasons. And many of that we already discussed could be good reasons to do that. But definitely good reasons to, an imperative to look into it. And in longer cases or borderline cases, which as Melissa and I have discussed, can be many of them, right? I think employers need to always be thinking about alternative options. One is not to allow it. You follow a policy for that reason. If there's any serious doubt, you're not going to allow it. Or if you do, knowing that you can pivot towards things that will make it safer and no longer remote work, which will be employing them in the jurisdiction through an EOR, a payroll provider, if that's an available option in certain countries, or using a partner entity or setting up your own entity. But again, those are where you're going to, fix it and legally. So that would be only if you need to have someone there or need them so badly you're willing to do that. But definitely reach out to us on any of those questions. And Melissa, so glad that you joined today. Thanks for coming.
Thanks for having me.
Thank you for listening to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate a workforce that is engaged and stable. Please tune into our next program where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on your streaming platform of choice, including Apple Podcasts and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com.